YouTube mic check. You heard me there?
The broadcast is now starting. All attendees are in listen-only mode.
Welcome to today's ABI Live webinar, this time hosted by the Consumer Bankruptcy Committee on what practitioners need to know about Chapter 12. Chapter 12 was born amid the severe farm crisis in the mid-1980s. It became effective on the day after Thanksgiving, 1986. I recall this period well, as I was the Senate staff person who was taking the lead on the legislation while working at the time for Senator Chuck Grassley of Iowa. Originally passed as a temporary measure, Chapter 12 became part of the permanent code as part of the 2005 amendments. Chapter 12 borrows liberally from Chapter 13, with some notable exceptions related to plan confirmation, operation by the family farmer post-petition, and importantly, the tax treatment of the debtor, the subject of an important 2012 Supreme Court decision, which we'll talk about later today. Today's discussion features three experts on Chapter 12, and I'd like to introduce them briefly now. First is Judge Rebecca Conley. She is the Chief Judge of the United States Bankruptcy Court for the Western District of Virginia, appointed to the bench in 2012. She's a former standing Chapter 13 trustee and Chapter 12 trustee for the Western District of Virginia. Mike Barnett is a lawyer from Tampa, Florida. He represents consumers and small businesses in Chapter 7, Chapter 12, and Chapter 13 cases throughout West Central Florida. Included among them are a number of Chapter 12 cases representing both debtor and creditor. And Mary Vigeland is the Chapter 13 and Chapter 12 standing trustee, appointed in 2010 to that role in San Antonio, Texas. Texas is one of the highest filing states for Chapter 12 cases. She has some 28 years experience in insolvency-related matters, not just in Texas, but in Michigan before that. And she's also famous for being a party to a 2015 United States Supreme Court case, which not everybody gets to do. So I thank very much our panelists for their preparation and materials for today, which those of you online have been able to link to. And at this point, be happy to turn it over to Judge Conley to get us started.
Thank you, Sam. Thank you very much, and thank you to ABI. It is my pleasure to be joined with Mike Barnett and Mary Vigeland as we talk about Chapter 12, which I think you will find is one of the most satisfying, rewarding, and unusual bankruptcy chapters. Mary, can you tell us a little bit about our background and the context of this special chapter?
Thank you, Judge. In reviewing the history of Chapter 12, I found it fascinating that really, up until 1986, there was not a lot of protection for the family farmer. And as a Chapter 12 trustee, I have a soft spot for the family farmer, but I also grew up on a farm in northern Michigan, and that farm is approaching 150 years in our family. So as I'm looking at the history, I went back to 1933 and found that in 1933, Section 75 of the Bankruptcy Act was passed, but it provided a very limited assistance to the family farmer, and it absolutely required the cooperation of the creditors. This was a temporary relief, and it expired on its own in 1938. The Fraser-Lemke Act expanded Section 75, made it a little more palatable for the family farmer, but it too expired in 1949. So between 1949 and 1986, there was very little relief for the family farmer, except trying to fit into that Chapter 7, 11, or 13. Fortunately, in 1986, Congress finally passed the Family Bankruptcy Act, and that added Chapter 12 to the code. It became effective on November 26, 1986, but again, it was a temporary relief, and it was a response to the tightening of the credit that was available at that time to the family farmers. For those who remember, that was about the time we had the failings of the savings and loans of the early and mid-'80s, and then that decrease in the price of the family for the farm property. Congress expanded or extended Chapter 12 several times between 2000 and 2014, but there are also gaps when Chapter 12 simply was not available. And I can remember during that period of time where, as counsel, you'd have to carefully time the filing of the Chapter 12 before it expired. But fortunately, Congress did make it a permanent chapter in the 2005 amendment. Now, Chapter 12 has advantages over 13 and 11. And as mentioned, it does closely mirror Chapter 13, but there are some absolute definite advantages. One of those is the increased debt limits versus a Chapter 13. If you look at Section 101, Parent 18, the aggregate debt limit is $4,153,150. That's a substantial amount. But you have to remember that at least not less than 50% of that debt has to be from the farming operations, but you get to exclude the residents. It gives a lot more flexibility with the timing of the plan payments. They can be monthly, they can be quarterly, they can be annual, all depending on the cash flow of the operation. You can also amortize that debt beyond the secured debt beyond the term of the plan. Cram down possibilities. Again, a fabulous opportunity for a family farmer, including the residents that we're going to talk about a little later. Tax advantages. You need to review Section 1222, which allows certain claims of governmental units from the disposition of a farm asset that tax may not be entitled to a priority. We're all familiar with Hall versus the United States, and pre-Hall, this was fabulous. I remember filing Chapter 12, liquidating real estate and reducing that capital gains to an unsecured debt, or reducing those real estate taxes that in Michigan we called PA 116 Act taxes, reducing those to general unsecured debt. But now we have post-Hall versus United States, and in that case, the Supreme Court held that the capital gains tax that was due from a post-petition sale of the property was not a tax debt incurred by the estate and could not be reduced to an unsecured claim. That decision still bothers me.
Well, I think there's some potential request to change the law on that, but we'll see how far that goes.
Well, and unfortunately, that's all we can hope for is a change in the statute. I mean, the exposure to the individual Chapter 12 debtor for this potential capital gains, which is a non-dischargeable debt, to me is just a significant burden that can be carried by them. Unfortunately, it is the law that we live with.
But there are still some tax advantages, aren't there?
There are some great tax advantages, absolutely. You have to read the Section 1222 carefully and the underlying case law to really determine how to take advantage of that, but it is absolutely there. It's just that post-petition sale of real property that may be contemplated in the plan or later a modification. You have to now be careful to carve out from those proceeds a sufficient amount to cover the capital gains for the individual debtors. I think that absolutely has to be taken into consideration to protect those debtors. We've provided a number of statistical graphs within the materials, and they're all very interesting, but I think the only stat that I'm really going to mention is looking at 1986, when it had the highest number of Chapter 12 files, 6,000 in a very short period of time. And the top three states were Nebraska, Texas, and California. Now, Michael, you were going to talk about Chapter 12 eligibility issues?
Yes. The eligibility is deceptively simple, I think, in Chapter 12. We already talked about the debt limits. One thing to be clarified on the debt limits is the overall limit, $4,153,000 per farmers. For some reason, fishermen is almost half of that, $1,924,550. That includes all debts, contingent, unliquidated, and disputed debts. But then another requirement, again, both for individuals and corporations, is that the 50% of the debt needs to be from farming operations. Now, in that calculation, you only look at, you exclude contingent and unliquidated debts in determining whether it's from farming operations. A couple of cases on the debt limits, the Johnson case, that one I think debtors may have been trying to play games. The debtors filed separately and each claimed half of the joint debt as their debt to try to get within the debt limits. The court said that didn't fly. They are still liable for the entire debts. Deciding on what is a debt and not counting towards the debt limits, the bond case, in that case, the debtor alleged that the creditor did not comply with the deed in lieu statute and alleged that they didn't owe the money and therefore didn't count towards the debt limits. The court rejected that argument and found they were ineligible and distinguished in the case between debts for which there's no liability cognizable at law and those which were valid on their inception but subject to affirmative defenses. So again, we're looking at total debts. Just because you have an affirmative defense, it probably still counts towards the debt limits. So as far as the debt from farming operation, that again can be more complicated than it looks at first. The Harmon case was fairly straightforward, where the majority of the debt was from misappropriating trade secrets and was not related to the farming operation. The court said that they're not eligible for Chapter 12. Divorce cases are a little more interesting. The initial case in here by Ben Pawson involved a marital settlement agreement, and the court looked at that and says marital settlement agreements aren't farming operations, therefore the debtor's not eligible. The Marlett case re-examined that and disagreed with that decision, but looked beyond the letter of the settlement agreement to determine that the marital division of marital property was intended to allow the debtor to retain the farm, and therefore actually the marital settlement debt was a farm-related obligation. So again, look behind the documents themselves to see whether the debtor may be eligible for Chapter 12.
Mike, let me ask you about that. So, your family farmer comes to you, and they, going through their situation, and you're considering Chapter 12. Now, how would you figure out if the debts are related to the farming operation as counsel? What kinds of things would you do?
Well, the first thing is most often, and on the debt, we also exclude, as we've mentioned before, the debt from the homestead of the debtor or the dwelling of the owner, unless that debt is from a farming operation. So many times it's fairly clear. Most of the debts, often the mortgage on the house, equipment, liens for the farm, arguably liens on individual vehicles that aren't used in the farm may not count, and just have to look at what each type of debt is and ask them what the money was used for. You really want to go look at the loan documents and lien UCCs anytime you have a reasonably close call, and see what the loan documents say. But usually it's not a terribly close call on those issues. So the debt from farming operations is again the same for individuals and corporations. The difference on eligibility for individuals and corporations is individuals have to have 50% of their income from last year, or from the last 2 prior years before that have to be from farming operation. If the debtor's coming in to see you, there's a good chance that last year wasn't a great year, and that's a recurring theme in a number of these cases, that they don't want to keep people from being able to file bankruptcy, farm bankruptcy, Chapter 12, just because last year was a bad year, because they had to sell equipment, sell land, do something in order to keep the farm alive. So if they had a bad year last year, they had 2 prior years, both of those years show that they were mainly farming operating income, then that still qualifies as a debtor for an individual.
Michael, what happens when you have a spouse who works off the farm, and that spouse has substantial income, and you've had a bad or 2 bad years on the farming operations? Can that skew the eligibility?
Yes, and that's again why you may have to look at more than 1 year. The many of the courts look at tax returns for the income, and whether it's farming income or not. Most of the courts are actually looking beyond the tax returns and looking at the actual reality of the transactions, realities of the income. Corporations are a separate test. You have 80% of the assets need to be farming operations, which you don't require for individuals, but they don't have to have the income test. You also have to have 50% of the stock or equity has to be owned by one family or the relatives of that family, and the stock can't be publicly traded. So that raises another interesting case, the McSwine Creek Farms case. This case, the individual debtor received a notice of intent to foreclose by the FHA, and they saw that they weren't eligible for filing individually. So then they went out and incorporated the corporation and transferred the assets of the farm to the corporation and filed 12 for a corporation. Bankruptcy, the trustee objected and said that was bad faith. The bankruptcy court actually rejected that and said that no, that's pre-bankruptcy planning and can be good faith. So that may be something that you can look at when your spouse has too much income. I won't guarantee that most other judges will follow that, and maybe they will, but that's at least one of the theory to look at. Unfortunately, it didn't work in McSwine Creek's farms because the loan documents prohibited transferring the property and ended up not being able to succeed in the 12 because of that case. Most of the cases we're looking at involve what is the definition of a farmer, and that, I think, has been evolving over time. The earliest cases we have represented by Dakota Laid Eggs in the materials. The courts looked at definition of agricultural, definition of farm, and other acts, the Small Business Act, the National Labor Relations Act, and eventually struck a fairly narrow definition of what is farming, and therefore denied the Chapter 12 in that case, or allowed actually an involuntary 7 in that particular case. The Sugar Pine Ranch case rejected that analysis. What Sugar Pine Ranch said is you look at the intent behind the statutes. The National Labor Relations Board Act, the unemployment workers' comp type statutes that were cited in a number of the cases, those were intended to minimize the exclusions from the protections in the Act for employees of the various businesses. Whereas Chapter 12, as we heard, there was a farming crisis involved. There was an intent to allow as many farmers as possible to keep their farms and intended for a more expansive definition. So Sugar Pine Ranch, where the debtor was basically raising cattle and trying to build up his herd and have a cattle sustainable timber operation, the court allowed that as a Chapter 12. Some of the other cases said that while small family farms should be qualified, agribusiness should not qualify. The Guinane case, also in the materials, rejected that argument, and this case involved a debtor actually was hauling cattle for third parties, and the court found that hauling cattle for other farmers in the neighborhood, in the area, still qualified as farm income because it was part of an integrated agricultural operation. And specifically note that Chapter 12 must include farming corporations and agribusiness. Some of the other early cases says that Chapter 12 doesn't hobby farmers. I think that may still apply. You have to show real farming activity, if not at the present time of filing, then at least in the past and intending to continue to farm in the future.
Michael, does that include the alpaca farmers?
I think it would. I think it has to include most anything that you can claim as actual farming. Like I say, I have a parrot case now. Alpaca, what would be different about alpacas?
Well, I mean, they've recently been in the news as to whether or not these are simply pets, glorified pets, or are they truly for farming operations?
Now, the Makey case, this is one that I've got in the materials too, and is actually one of my favorite cases, specifically talking about the expanding definition of farm. It goes into a great deal of detail about how farming has changed over time. The Makey case actually involved raising puppies from 8 weeks of age to resell, and said that qualified as farm income, farming operations. the creditor, one of the creditors says, if it's not raising produce produce for human consumption, then it's not farming. Another creditor says, well, human use or consumption. The court said that it doesn't depend on recognition of the debtor's enterprise as a traditional farming enterprise. Farming as an enterprise has changed over time, and the definition has to change over time. So I think certainly if puppies qualify as a farm operation and alpacas do, again, you're going to have different cases throughout the case law, but there is certainly support for the position that even raising pets qualifies. And in this Makey case, they didn't even breed the pets themselves, the puppies themselves. A significant percentage, I think it was 60-70% of the dogs were bred by other people and then raised by these people, medicated, and then sold out afterwards. And the court still said that that qualified as farming operations. Again, a lot of other... Go ahead.
What do you think, Mike, about a vineyard? Would that be a farming operation or chapter, eligible for Chapter 12?
The grapes is one of the crops mentioned by the Makey case as one of the changes in farming operations, and I think you're going to have to look somewhat beyond the name of what they're doing and see how much of the business is selling wine, how much is producing wine, and how much is growing grapes. I think there's certainly an argument that the debtors would use that is an extension of how you package the material that you're growing. I might make that argument if I were a debtor's attorney, that just because you're packaging the produce in wine bottles instead of packaging them in regular crates, that should not make you ineligible for farming.
Mary, I think you've had...
Right.
Would you
Michael,
look at those?
I have, and would the scenario be different? Because so many vineyards now are a combination of a vineyard, winery, and social interaction, whether it be wine tastings. A number of them now have restaurants on site. So does that, they have the vineyards producing the grapes. They may use some for their own production. They may sell some to other wineries. They have their own winery, but then they have the wine tasting. They have other events. They have the wine club. They have a restaurant on site. Would any of those factors change eligibility?
Possibly. There is a case in the materials, Vecchione, I guess, talks about where a debtor tried to file for Chapter 12 with property that had recreational activities, ice skating, skate sharpening, sledding, and hay rides, and the court said that didn't qualify for a Chapter 12. But again, as a debtor attorney, I would go back to Gucciani and say this is part of an integrated farming operation, and you can have some aspects of it that look like restaurant or entertainment or trucking or something else, so long as it's all part of an integrated operation that is fundamentally still farming related. Okay. But that's something that, again, certainly could be a fight. But the other thing you have to look at on some of these is the creditor advised to fight over the debtor being in Chapter 12. Often, and in many of my cases I found, creditors are convinced that it is much better to be in Chapter 12 than to force a debtor into Chapter 11 bankruptcy. The expenses is much less. That's the Buchanan case talks about this. Chapter 12 was enacted because many farmers exceed the debt limits for Chapter 13. Chapter 11 is often needlessly complicated and unduly time-consuming and inordinately expensive and in many cases unworkable. My last Chapter 12 that I got confirmed, my total attorney fees in the case was less than $5,000 despite cramming down a homestead over an extended time period, which, again, I think is the biggest advantage in Chapter 12. So, again, many times, and in fact, most of the time I've had the cases, the creditors don't want it in Chapter 11. The creditors would prefer having the less expense, both for attorneys, for administrative expenses, for everything to be in Chapter 12 than to be in Chapter 11.
Like, have you noticed a difference in the in that issue with the kind of creditor? Is that the same whether the creditor is a commercial lender or whether it's part of the government, Farmers Home or FHA or rural housing, something like that? Is there any difference in your experience?
I have not seen a defense in that. I haven't had, again, most of the time, the only fights I had is when a case started out in Chapter 11 and then converted to Chapter 12. In most other cases, it may depend on whether they think you can't cram down the homestead. They may be more likely to fight over that. But no, I have not generally had fights over that. And I've had some cases. I had one of my earliest cattle cases, again, similar to one that we have in the materials. The debtor owned no cattle, owned no land, but was leasing land and had other people's cattle on the property and got half of the calves from it. And nobody wanted it to be in Chapter 11. The judge, the trustee, and the creditors all thought, yes, this is going to be much cheaper, much more likely to succeed in Chapter 12 than Chapter 11. Mary, I think you've had some cases where you were able to convince creditors not to try to force it into Chapter 11?
Yes, I had a recent case, just completed, where the debtor had at one time cattle and had hay and a few other small crops, and discovered a deposit of gravel and began allowing a mining company, a gravel company, to come in and mine. Obviously, the income from that was substantially greater than from the livestock, and one of the creditors initially wanted to argue that as a result, this was no longer qualified as a family farmer. And after a few meetings and convincing the creditors that it would be much less expensive and much more likely to be supervised in Chapter 12 than in Chapter 11 because the debt limits were over the 13, we all agreed to allow it to remain in Chapter 12, and eventually all creditors were paid in full.
Again, that's sort of my experience, that the creditors most of the time don't want to fight over that. A couple other issues on income. Rental income is something that you'll see coming up reasonably often. The Creveston case, the Burke case, both talk about that. And again, the court looks at the history of the farm and why the rental arrangement was set up initially, and whether it's renting from relatives or from third parties. The Burke case goes into some detail and some presumptions created from a rental agreement. There was a 297-acre farm. It was put in a corporation with the principals being the debtor's 3 children, and then leased back to the farm on a crop share basis. And I think that's important, both that it's to the relatives and that the debtor shares in the risk of whether the crops are successful or not. The court created some presumptions in that case that crop share leases typically are farm income. The cash rent with family members, they say, is presumed to be farming only if past farming operations are more in short-term or sporadic, and any cessation of farming is just temporary. And cash rent with non-relatives creates a rebuttable presumption that it's not engaged in farming. Again, cash rent is simply where you pay a lump sum amount for renting the property without regard to whether the crops are successful or not. Crop share, you get paid a percentage of what gets sold from the crops. So what's not farming? Van air flying services, crop dusting, seed sowing. The court said that's not a farming operation. Another Florida case here, black welder harvesting, where the debtor just harvested citrus from other people's groves. That was held not to be farming. Again, when you're just dealing with other people's property and somehow treating or doing something with other people's farms, you're less likely, or generally not likely, to be held to be farming. The Cluck case, there's a number of cases on horses, and I have a number of cases on horses, and we get some conflicting cases. The Cluck case was a debtor who bred, trained, and bored horses, had 2 stallions, Impressive Barleo and Impressive Ben. I love the names of those 2 horses. And the court decided that that did not actually, was not subject to the risks of farming, the vagaries of weather and other controllable conditions. That case is frankly hard to reconcile with the Buchanan case, so it may be just up to what judge you end up having. the current status of the farms, as we mentioned before. If there's an intent to keep farming, but not significant farming activity doing, or not a great deal of farming activity done when the case is filed, they should still qualify as farming. We have the Tart case where up in North Carolina where they were filing in midwinter when no farming operations could take place, but they were going to plant in the spring. Court said that qualified. Nilsson case, there was a longtime dairy farmer that had a few cattle when they filed the case, but then everything was repossessed between filing and confirmation. The court said that there was not required to be farming at the time of confirmation, only at the time that the debtor filed, and temporary cessation of farming is not disqualifying. But compare that to McLaughlin case, where the debtor was receiving Social Security income and received a lawsuit money from a settlement from a lawsuit related to farming operations in the past. In that case, the court said that while the settlement income was farm income, even though it was proceeds of a settlement, because he had no intent to restart the farm, he was not eligible for Chapter 12. So again, look at what they're doing now and if they don't intend to go back to farming, then you're probably not going to succeed. Just a few practical notes. If you have a debtor come in and you want to look at Chapter 12, as we mentioned, look at the loan documents, look at UCC's perfection of loan documents. Be sure you know the priority and validity of the liens on the properties. Maybe a good idea to visit the farm and spend much more time than you do in Chapter 13 in some other cases projecting disposable income going forward. You want to know where the money is coming from for the next year's crops, what you're going to spend on fertilizer, on seed, on pesticide. Try to get very detailed figures and do a projected budget going forward for what you're going to need in the case.
Mike, how do you do that with an entity that may not have monthly income? If their income is from these periodic sales, if it's somewhat seasonal, how would you put together a budget?
You look at their past figures, what they've done in the past, and generally the farmers I've had know who they get financing from, who they want to get financing from for next year's crop. You'll need to get debtor in possession financing order. That is often what I have the biggest fights over, and that very much depends on the budget and seeing, are you including all the items in the budget that you're going to actually spend. If you leave out property taxes, if you leave out some aspect of it, the creditors are usually going to be very familiar with the farming operation and will raise anything that you leave out. So that's, I think, you want to try to prepare those projected budgets as well as you can even before the case is filed. So you want to know what your plan is when you file the case to keep the farm alive, if at all possible.
When you're seeking that post-petition financing, what do you do about the fact that your farm may not be able to make monthly payments? Is there anything you can do?
The post-petition financing arrangements, again, are similar to what they would have before they filed bankruptcy, and they anticipate annual payments. They anticipate getting paid generally from the sale of the crop that they're financing. And again, they will have fairly close requirements for fertilizer, for pesticide, for how you have to grow the crop. But that's, I think, to be anticipated in agricultural farm businesses.
So unlike Chapter 13 and Chapter 11, you can actually have no payments for 11 months and then one payment once a year, and that would be acceptable.
And that's what they do outside of bankruptcy, I think, in most of these cases where you are surviving on one crop a year. Now, in Florida, we may be able to have multiple crops. You have someone with strawberries and then watermelons after the strawberries are done. But they get paid when the debtor gets paid, and that's essentially the only option for a real farming operation.
Mike, you mentioned something about looking at the loan documents, checking liens and priority. Why would you be doing that before you filed?
You want to see if there's a basis to challenge any of the liens. I've actually had errors on legal descriptions. One person who thought they had a lien on the house actually had a lien on a 10-foot strip next to the house. They have you want to know what priority the liens are. Be familiar with the IRS 45-day rule that the creditors have time to perfect even after a IRS lien is put on the records, and know what liens you can strip. Again, that stripping down of the homestead is one of the biggest advantages in Chapter 12, and something I do in a large number of cases.
You can strip down a home mortgage? You mean if the mortgage is secured by the debtor's principal residence, can you modify it?
You can still strip it down. What I often have are cases where we'll reduce the debt down to the value of the property. The last case, that one was $5,000. We stripped more than half of the debt off of the mortgage and allowed, in this case, a 20-year repayment term. First 5 years in the bankruptcy, the rest outside of the bankruptcy, and again reduce the interest rate. Even if some cases, in my last case, it was 4.5% is the interest rate that we agreed to. Everything is negotiable on there. You can negotiate longer, shorter payment terms, negotiate the interest rate, and negotiate the values. And
so you just said you could take the debtor's residence, reduce the value, you determine the value, and the value is a low figure. You can then spread the debt out over a period longer than 5 years? Is that what you just said? Wow.
That's one of the biggest advantages in 12, and is one of the most important reasons to file Chapter 12 in many of the cases that I've done.
Mike,
during
with
that cram down,
I'm sorry, go ahead.
During the cram down period, would you be making payments through Mary's office, through the trustee's office?
That's what we do here. I don't know that that's universal among the courts, but the trustees and the judge here are going to insist on doing that. And I don't have too big an objection over that. It may help in accounting, and the benefit that the debtor is getting out of that outweighs the trustee fees. That I think that benefit that they get by stripping down the mortgage certainly outweighs the fees that we end up paying to the trustee.
Mike, I was going to ask a question. Going back to cramming down on the residence, would the outcome be the same? For instance, if the debtors have bifurcated 10 acres and they have a separate deed for 10 acres surrounding the home, and that property has simply a traditional mortgage on it, residential mortgage, and the rest of the 100 acres is all farmland with its own, but the value of the house has decreased substantially. Could the debtor still cram it down even if that property is not tied to all of the agricultural real estate?
The limitation in Chapter 13 for the property secured by a debtor's homestead simply doesn't apply in Chapter 12. That provision's not in there. So I think you can do it with any of the property if you are eligible for Chapter 12. The trick is being eligible for Chapter 12.
Okay.
Once you're in Chapter 12, you can modify any secured debt.
Yes.
Oh, great.
Mary, what can you tell us about cash collateral adequate protection, and maybe even what do you expect at 341s, and what are debtors not doing right or doing right at 341s?
What I'm going to want at that 341 is I'm going to want 2 years of tax returns, because again, I want to look at the eligibility issues as well as being able to determine perhaps what some of the sources of the loss typically have been. I want 1 year bank statements. I'm going to want a year-to-date profit and loss to the best that the debtor can do at that point. And it may be sketchy based on the time of the year. If it's early in the year before crop inputs, I'm probably not going to have a lot of information on that. I'm going to want all the loan documents with the UCC statements so that we can determine rank, validity, and priority of lien. I have found that so many of the bank and farm service agencies are borrowing or lending money to the debtors at virtually the same time. and virtually taking the same collateral on the UCC statement and in the security agreement. And so determining who is first, and it may be by a matter of days, is extremely important to determine who's going to get crammed down. I'm going to want a list of the equipment with the values, the depreciation schedule that was attached to the last tax return. Again, I had a recent case where, debtor gave me 10 pieces of equipment on Schedule B, and yet when I looked at the depreciation schedule, 100 pieces are missing. The answer was, well, I thought I only had to list those that I still owed money on. So that depreciation schedule can be a wealth of information. List of the livestock, again, I have a polo pony player with 100 horses. Only 5 horses were listed. The other 95 were on the depreciation schedule. So we can learn a lot of information from depreciation schedules. I'm going to want real estate tax statements so that I know an accurate number of acres and what the value for the county is. The pro forma with a plan, when you do a plan, I think you have to have at least a 12 to 24 month projection showing the cash flow to substantiate those plan payments. The other thing I'm going to do as a trustee is I'm going to do a site visit. I'm going to go to the debtor's farming operation.
It's all good information to know. I did see a question on here asking for a case law saying that Section 361 adequate protection does not apply.
That is correct.
That's simply under Section 1205A says specifically Section 361 does not apply in Chapter 12.
Yes, so I don't know that you really need any case law because the statute is so very clear.
Yes.
On that
Now,
issue.
1205, but 1205 provides its own provisions.
Yes.
That's right.
Regarding adequate protection. So that's just basically where you need to look, is just look to Section 1205.
That's correct. Yeah, we're going to begin talking about cash collateral. With respect to cash collateral and adequate protection, one of the things I first wanted to talk about quickly was the co-debtor stay under Section 1201. It really has to be a consumer debt, and it doesn't apply to debts incurred in the ordinary course of that individual's business. So the co-debtor stay is not as expansive in 12 as people may think. In fact, it's identical to Chapter 13. So if you have this issue come up, you can always look at the case law in Chapter 13 on the co-debtor stay. A couple of cases that you are going to want to look at is In Re SW Inc. out of the Southern District, California, and where they talked about the co-debtor stay doesn't apply on personal guarantees. In this instance, it was a corporation, but if the personal guarantee was for the purpose of farming operations and not necessarily limited to a consumer debt, the co-debtor stay is not going to apply. An interesting issue that we had come up here in the Western District of Texas, and there is, I believe it's a published opinion, it's called Colvin versus Amagi. Husband filed Chapter 12. Both he and his wife are on the note for the residence. The lender files a relief from stay as to the debtor only, and then they attempt to foreclose. The debtor tried to play a gotcha game by invoking the co-debtor stay. And the judge looked at this and didn't really like the gotcha game and said he would retroactively annul the co-debtor stay based on the balancing of the equities of the parties and allowed the foreclosure sale to stand. So I think as the lesson for the creditors is always going to be always include in your relief for request for termination that the co-debtor stay also be terminated. You can do it in one pleading. For the debtors, don't think you can necessarily hide behind that co-debtor stay, because the court has the ability to annul it retroactively.
On the co-debtor stay, two other points I just wanted to follow up on. One is when there is a request for co-debtor stay relief, just like in Chapter 13, it could be self-executing. Failure to respond, the stay will be lifted after 20 days. But also, I wanted to follow up on something Mary said and something that Mike said about that in chapter, the co-debtor stay is perhaps going to depend on the purpose of the loan. And Mike talked about taking a look at the loan documents. I want to reiterate that if you want to know if the co-debtor stay will apply, you really need to take a look at the loan documents, because that may be critical to the court's determination about whether it really was for the purposes of the operation or whether it was for consumer purposes.
Well, and Michael, I was going to ask you actually a hypothetical, and that is, the husband and wife execute the note. The note's entitled commercial line of credit. But the debtors have told the bank, I'm going to use part of the money for my farming operations, but I need to make a few repairs to the home. And the bank consents. Now the debtor files. Could you argue that the co-debtor stay applied and that the bank acquiesced, knowing that some of it was going to be used for non-farming operations within the household? And I've had this happen, and I thought about this.
I think you certainly can make that argument. A number of the cases, again, some of the initial cases we're looking at whether it was a farming operation by looking at what was on the tax returns. I think I would make a similar analogous argument on that case, saying you have to look behind the documents, look behind the tax returns, look behind the loan documents, and look at the reality of the transactions, what is actually going on. And certainly a possible estoppel argument against the bank once they know that it's being used for other funds, other purposes.
Okay. Now let's talk about cash collateral and adequate protection. As I often say, farmers are asset rich and cash poor. We have family farms that have been in families for several generations, and there's substantial equity usually in the real estate. But because of cash flow in farming, it's either feast or famine. So we have to look at, I would start with Section 1205, and yes, Section 361 does not apply. But 1205B does say that adequate protection applies under 362, 363, and 364. And that there's certain requirements that you have to be able to provide for adequate protection, and that is either the trustee can make a cash payment or a periodic payment, and that it be able to, doesn't result in a decrease in the value of the collateral, have to provide for that replacement lien. Perhaps you can pay the creditor the equivalent of reasonable rent or other relief to protect the collateral. Michael, have you ever argued that the equity cushion results in sufficient adequate protection so that the debtor can delay starting those payments?
Yes, I think that's particularly true in Chapter 12 also. Many times, almost all the farmers are cash poor and land, and that's what you have to use, particularly with just getting annual income, as many of these do. You have to use the equity cushion as adequate protection because there's not other cash to come in to pay the creditors.
So if you're preparing, Michael, for that Chapter 12 and you know that this is going to be an issue, that creditor is going to want some adequate protection, do you go ahead and have an appraisal done of the real estate to establish, going into the case, that equity cushion? Or do you wait until the creditor disputes the value and the equity cushion?
It's depending on the circumstances and depending on how much money the debtor has. Unfortunately, we're stuck with practical considerations as debtor attorneys in that we don't have the deep pockets that many of the banks have. So we may have to wait to see what the bank does. Also look at the loan documents. If this is a debtor that only has annual income, then you're much more likely to see loan documents that only require annual payments.
But once they come into Chapter 12, can't that creditor ask for a payment in advance of that annual payment under the loan doc, knowing that it may take some time for the plan to be confirmed? Can't they ask?
I think they can ask, and I think, Judge Connolly, would you look at the loan documents and say, They agreed to annual payments initially. That's maybe what they're stuck with.
I think that's pretty persuasive. You know, we would hear these disputes, and the farm cases are always going to be fact specific, and so there may be a case in which I couldn't rule in your favor, Mike. But generally speaking, simply because the debtor filed a Chapter 12 doesn't change the fact that this lender was willing to loan to this farm operation on those particular terms where that creditor was getting paid on an annual basis. Now, while there's some change in Chapter 12, I don't know that based on the language of 1205 by itself, that I have to compel payments on an accelerated basis beyond what this creditor already agreed to outside of bankruptcy. So that would be persuasive. I can't say it was controlling because I don't know the circumstances. We would have to hear it. And these cases can get emotional. I suggest that you take the time to try to consult with the parties, either if you can before filing or immediately after filing, because it will save expense and angst in the end for having to bring this before the court. I mean, if I'm going to have to order some sort of replacement lien or some sort of payment, accelerated basis from your loan documents, that could just kill the Chapter 12 operations.
Right. I think as a practical matter, I have seen adequate protection requested for the equipment because it's being used daily and it does depreciate. And again, we typically have negotiated not a monthly payment, obviously, but some type of periodic payment prior to confirmation. That's really where I typically have seen AP requested, not so much with the real estate that has on its face an equity cushion. And you can look at In re Wilson out of Montana that talks about the equity cushion can constitute adequate protection. Scottsdale Medical Pavilion out of the Ninth Circuit says, you can go to the underlying state law to determine who has an interest in property. But an interesting question I always look at is, what about giving a lien on future crops? Is that sufficient for adequate protection, or is the nature of farming so risky that that's not enough? I don't think giving a promise to give a lien on future crops is enough for AP, but I also would have to look at the case. I think if it's a dairy case and you're giving, the future rights to the milk that's produced, that might be one thing. But what about actual crops, Mike?
Again, I would look at the loan documents and what did the creditor agree to initially. If their initial agreement was a lien on the future crops, I certainly think that they should be stuck with a lien on the future crops and would argue that at least to the judge. And as a creditor attorney, then I would want more and argue that, and at least argue what the debtor needs to do to make that more likely that the crops are successful. But as we all know in farming cases, you can do everything right and either have a great year where everyone has a great year and the crop prices plummet and you still don't make any money, or have weather or disease or something else come up that even if you do everything right, you may not have any money.
Mm-hmm. Well, but let's talk about future crops. Okay, so the UCC and the security agreement provides they have a lien on the future crops. But the crops aren't in the ground on the date the debtor files. Isn't the creditor only secure to the collateral that exists as of the petition date? And if the debtor timed it and plants his crop post-petition, isn't that potentially an asset that's not perhaps subject to a lien that he could use either for future negotiating with that creditor or to have perhaps obtain some other post-petition financing that he may need?
I would look at the loan documents and I think it's going to be fact specific. But it's certainly something you may want to think about as a type of pre-bankruptcy planning as to timing your filing.
I used to do that as a debtor's counsel. Is try to time that.
Most of the time, I would think that the loan documents are going to be pretty expansive, but it's yet another tip for why you want to check that. And if you have the time, you may need to think about the timing of filing your petition.
Mike, what about any tips on discharge? Anything that we need to know about the discharge issues?
Yes, there's discharge doesn't seem quite as complicated as certainly eligibility. The requirements on discharge are under Section 1228 A and B. Again, we have a regular discharge and a hardship discharge similar to Chapter 13. It's interesting to note that the regular discharge is similar to the hardship discharge in 13, though, in that all of 523 is excluded from the discharge. So if you have property settlements you're wanting to deal with, association fees, 523A6 type issues, those are not going to be discharged, and you need to at least be aware of that when you file the case. Hardship discharge is when you can't complete the payments. It has to be circumstances for which the debtor should not justly be held accountable. You have to have met the liquidation test, and modification is not practicable. Again, Section 1229 deals with modification of plans, and when you can do that, we have a couple of cases on that and the very good materials that Judge Connolly had prepared. Hardship discharge is limited just to unsecured debts, though, so be aware of that. And very often, if you're doing something with the secured debts, that's going to limit your ability to do much with a hardship discharge. You also have to be aware of 1228B, that they can revoke the discharge. It has to be within 1 year of when the discharge is entered, and the moving party must not have known about the fraud until after the discharge is granted.
Mike, let's talk a little bit about the secured debts. You know, you talked about taking the debts and spreading them out over a long period of time. Is that discharged? Are those debts discharged?
I would argue that they are, and again, it depends on what we're doing. If you're doing a long-term amortization, the 20, 30-year valuation of the homestead, theoretically, you can still keep the plan in effect and keep paying those. I haven't had that come up and haven't had that come up in any of the cases, but arguably you can still comply with the valuation requirement. If you're paying equipment over 5 years through the plan, can you modify the plan under 1228 to say you're going to pay 1 year outside the bankruptcy? I'm going to bet that Chapter 12 trustee would object to that. But it depends on your situation, and I think land, it might be possible to argue that, but when you're paying the secured creditor entirely through the plan, it's going to be a much tougher argument. Do you have anything else to add, generally on Chapter 12, Judge?
I think that just a couple points. One is just that Chapter 12 really is very typically is a very rewarding experience for all involved. They tend to be some of my favorite cases when I was debtors counsel trustee and now as judge. And I would encourage the bar to just not be afraid of Chapter 12. Biggest hurdles you're going to encounter are eligibility. But another point I want to make is that it's confusing when you get into the debtor in possession provisions because you have a hybrid between 11, 12, and 13, or 12 is a hybrid with 11 and 13, so that the role of the Chapter 12 trustee is kind of a little of everything, and the debtor has a role that's a little bit 11 and a little bit not. So I would just caution you on understanding the different hats that people wear, and try not to get at odds with your Chapter 12 trustee. But I would again encourage everyone to explore with this, explore it. Don't be afraid of it. Follow the advice of people like Mike and Mary, and I think that you really find it very, very rewarding.
All right, thank you.
Okay, we have another question, I believe. And the question has to do with, should the interest rate be higher than Chapter 13 due to the risk involved with the operations? Some courts allow prime plus minimum risk percentage. And interest rates are always going to be, unless they're agreed to, that's going to be a contested issue, and you're going to need to have lenders probably provide some evidence to the court of what would be an appropriate interest rate when you are spreading something out over a very long period of time, when you are dealing with a high-risk type of operation. And so there is no one set rule for interest rates. It's always going to be situational, and sometimes that can be a sticking issue.
Again, I try to negotiate all of these issues if at all possible without having to go before the judge. I prefer knowing my risk with an agreement with a creditor, knowing what sort of payments we have and something we can afford. If we can't reach an agreement, interest rate fights are going to be one of the more problematic, I think.
They certainly are, and don't underestimate that. Again, that's why you really want to consult the lending operation. I think one of the biggest mistakes debtors make is they assume that they can just pick a low interest rate for the entire time period that they're spreading this loan out and think that that's going to fly. And if there's a contest, it may or may not. I don't know if we have any other questions. Another question came in. If the debtor owns the farmland, but a non-filing party performs all the farm duties, rents the property, can the owner still be eligible? Oh, boy.
That's some of the rental income cases in our materials have similar to that. The Burke case and I think Creviston both allowed the debtor being eligible where the farm land was leased by the debtor to a corporation, and then the corporation did the farming, and the relatives of the corporation, relatives of the owner were owning the corporation. And again, the debtor allowed the individual debtor to be a Chapter 12, in that case with a 60-40 crop share basis. Creviston also looked at, I think, were relatives of the debtor, income from the debtor to the individual debtor from the corporation created by the debtor for the use of the farmland equipment and debtor services qualified, that are still qualified as Chapter 12, and that income was treated as farm income still. So look at the Creviston and Burke cases and cases along that line, and certainly there's a strong argument for debtors, depending on the situation. If you're getting rent from a third party that you're not related to, you're going to have a much harder case, particularly with cash rent.
I don't see that we have any other questions. Back to the role of the Chapter 12 trustee and the role of the debtor in possession. Have either of you encountered a time when a debtor in possession has been removed as debtor in possession?
I had knock on wood. We were talking earlier, and I said I had a situation, and this goes back to the case I just completed, where I actually filed a motion to modify to sell some of the real estate and to be a little more proactive on liquidating the assets because it had been several years and there had been no movement forward by the debtor. Now, I did this in negotiations with the debtor. The creditors were beginning to lose confidence in the debtor. And we knew that the debtor was not going to be successful in filing another modification to extend the time to sell this property. So I did it, and I did it in agreement with the debtor. And what we did is we did a hybrid of 1204, which, so not providing for a total removal of the debtor as a debtor in possession, but blending the responsibilities of the trustee and the debtor to work in cooperation to liquidate this property. we would agree on a realtor. If we needed to go to auction, we would agree on an auctioneer. If we couldn't agree, ultimately the court would be the deciding factor. But that's what, at the end, gave confidence with the court and the creditors that it would actually get done, is if I took an active role.
Mary, do you require the reports, monthly operating reports?
I require periodic reports, and it's going to depend on the nature of the farm. In that respect, it was primarily from the sale of gravel, so that was easy to get the records every month. If it's a cash crop, I'm probably only going to want to know what everything sold for at the time of sale. Or I'll look at the bank records at the end of the year. It's really going to depend. If it's a dairy operation, I'm going to want to see those records every month. If it's a sale of livestock on a regular basis, I'm going to want to see those when they occur.
Mike, is that something debtors counsel gets involved in, actually helping with the operating reports for or tax returns for your debtor client?
I don't do tax returns. I'll review them and make sure that they are that we see what's going on in the case. Most of our cases, we are not requiring monthly reports. Again, it depends on the nature of the enterprise and the nature of the farm. And again, I go back to the case talking about we don't want to turn Chapter 12s too complicated if there's not a need for the complication. So we're not wanting Chapter 12s to turn into Chapter 11s with all the is related to that. So it's again fact specific in every case, and understand what your trustee wants in your particular case. But I don't want to add complications where it's not needed.
I think we have another question. In a dairy farm operation, can a secured creditor compel debtor to improve the pasture in order to increase dairy production?
The creditor offering money to do that?
I don't know what authority the creditor would have, and that I could then use to compel the debtor to improve. I'm not sure exactly what was being asked, really, in terms of what kind of improvements would be made for the dairy operation. There might be a question as to whether this debtor is going to be able to present a feasible plan, whether they are proposing a plan in good faith, so the debtor may have an incentive on its own to want to improve its operation, but I'm not sure how I can compel him to do so. Another question, do payments to secured creditors from the sale of farm assets through an escrow have to be paid by the Chapter 12 trustee, or can the payments be made directly by escrow without the payment of trustees' fees? I guess, both Mary and Mike, perhaps you can talk about the practice. There's some case law that says payments need to always go through a 12 trustee, other case law that says no, they do not. What has been your experience with using escrow?
I'm going to tell you, in a 12, I've always required the payments to go through me for a couple of reasons. One, like in the last case, I did a lot of work on the auction, and for which I think I should be compensated, as does debtors' counsel want to be compensated. I think that this case law that says simply trying to avoid a fee is not an appropriate justification for doing so. But on other things, when it's been a smaller sale and it pays that creditor in full, I've let it go if I haven't had a lot of involvement. So for me, it really is going to be sale specific and how much time I've been involved in that sale or in the case. But for the most part, I'm really going to want to be the one in charge of all the accounting.
Mike, how do you see it?
I think it can be fact-specific. I haven't had many sales, and ones I've had, I think, were two different trustees, Chapter 12 trustees. It seems like the last one I had was before the prior trustee did not insist on having anything go through the trustee's office for sale of actual land or large portions of the sale. And often you'll see debtors having to sell farm land in order to keep cases alive or keep the farm alive. Now, what they'll do is sell that farmland and then use any net proceeds to make planned payments, so the trustee ultimately ends up with it. But again, it's going to be fact specific.
It is, and it's going to be planned. I mean, if the plan calls for liquidation, then you're right. The sale of that probably becomes a planned payment. You also have to remember that the trustee fee is not going to be a straight fee. Depending on the amount of the sale of that asset, the trustee's fee will automatically be reduced. If you look at the statutory language on our fee, if it's over X number, and I can't remember how many hundreds of thousands of dollars it is, but the trustee fee goes down.
And Mary, that's statutory, right? You don't have the ability to just negotiate a higher or lower fee, do you?
That is correct. I cannot.
And I don't know of any authority that I could order that you alter your statutory percent fee.
But yeah, my recollection is if in any particular case in a given year, if revenue exceeds, I don't know if it's 300,000 or 400,000, my fee automatically goes down to 3%. So it's built in by statute.
And with these large sales of farm properties, that could very well happen.
Absolutely. Happened in my last case. Mm-hmm.
In our last minute, do either of you have any comments regarding Chapter 12? Any favorite cases?
Again, the Makey case is very good about the history of the evolution of farming, and I think it makes a very good argument that you have to consider the eligibility of what is a farmer to evolve over time. Mary, you have any?
Yeah, I agree. I think that people shouldn't be afraid of the Chapter 12 trustee. I think that this is the one area where we bend over backwards for the family farmers. And clearly these are the cases where you really want to see the success. I think this is also the cases where the creditors want to see the success. It's not typically a litigious chapter to litigate in. I think everybody wants the same outcome. So don't be afraid to work with the Chapter 12 trustee and make them your ally.
I have found Chapter 12 trustees, and the trustee, even the same trustee in Chapter 12, to be more reasonable, more willing to work with a debtor than often I see the case in Chapter 13.
Mm-hmm.
Well, you certainly have a lot more flexibility, and I think it lends itself to a much more consensual effort. And so I too have found, other than perhaps eligibility and then occasionally those interest rates, we don't find that Chapter 12 has quite the same tension that you find in some of the other chapters. I think we have one last question, and that is one for clarification. Someone cash renting, do they qualify?
The presumption talked about in the Burke case is if it's cash rent with family members, it is presumed to be farming income only if the past farming operations were more than short-term or sporadic, and any cessation of farming is temporary. If it's cash rent with non-relatives, it creates a rebuttable presumption that the debtor is not engaged in farming. Again, that's just one case, but that's the first case I would look at and look at its progeny for any case research.
Well, the eligibility requirements will certainly just be case specific, and numbers, percentages, values, that's going to be determinative. But I think it's wonderful that people are thinking outside the box, and I hope that everyone has picked up something about Chapter 12. Maybe we'll start seeing an increase in those statistics sometime in the upcoming years. Well, thank ABI for putting this together.
Well, many thanks to Judge Connolly, Michael, and Mary for a great presentation today. Very insightful on the number of surprising features, perhaps, of Chapter 12. And thanks to our audience also for the questions. Today's program is an example of dozens of audio and video CLE programs across all insolvency topics found online at cle.abi.org. Most are free or for a small fee, and some qualify for distance learning credit where approved by states. In July, we have 2 regional conferences coming up: the 24th Annual Northeast Bankruptcy Conference in Newport, Rhode Island, July 20 through 23, and the 22nd Annual Southeast Bankruptcy Workshop at Hilton Head Island, South Carolina, on July 27 through 30th. See abi.org for more information about these and other programs. So until next time, this is ABI's Executive Director Sam Giordano saying thanks for listening and have a great day.